to simply smile to the banks. We're all challenged.
Yes. There's a more profound thing to be focused on there. But I mean, given the thesis you just put out at the moment, which is a very interesting and comprehensive one, I mean, now that we are where we are, in spite of the Uwais committee and all the rest of it, do you or don't you see this particular election, presidential election petition or petitions becoming a sort of locus classicus, as it's called in your legal circles, a first-time precedent-setting case?
No, we have had cases of this nature.
Yeah, but it's never quite got. I mean, it's never been decided in favor of someone who's making an application. Against the result.
Yes, you know.
Yeah.
But again, I go back to the 2007 presidential election.
Well, it came close, but it didn't do it, did it?
It was a 4-3, 4-3 justices of the Supreme Court. So it's a split judgment. It could have been either way.
Yeah.
So again, as I said earlier, it depends on the evidence produced. A couple of African countries, presidential elections have been allowed by the court. In Nigeria, a number of election petitions in the states have succeeded,
right,
in which sitting governors have been removed. So there shouldn't be any cause for, you know. So
from your perspective, it's entirely focused on the weight of evidence
for sure.
that is submitted.
For sure.
And you feel confident or not confident that justice will be delivered in the courts in that context, that there isn't a political element to it?
For me, because I go to the court every day.
Right.
Even though the courts in any capitalist society are not neutral with respect to the political development of...
Well, certainly the Supreme Court in most countries is not neutral, including the United States.
It's a political, you know, the Supreme Court 100%. Is a policy court.
Yeah.
I mean, you know, and so there's nothing extraordinary, there's nothing strange with developments in this country. Again, going by our experience, in 2007, 2011, a lot of governorship elections were annulled. The results were annulled. So, by the courts.
The states are, of course, a bit higher when it comes to the presidential level.
No, they're always very, very high. Always. Because of the interests that are involved.
Yes.
And this time around, again, as I stated earlier, a lot will depend on the evidence.
Yeah,
and issues of law raised.
But based on what you've seen
for instance,
so far,
yeah.
I mean, do you expect it to be an epic battle?
It's going to be. Even though the respondents haven't fired their defenses. And until that is done,
that is
one
true.
is not in a position to weigh the type of evidence to expect. So we have only heard from the side of the petition.
Right.
We do hope that as soon as possible, you know, the respondents will fire their responses.
Absolutely.
And then we can look at the weight of evidence that is likely to be adduced by both sides.
Yeah, that's a good point. But let's move slightly away from the evidence. The former president of the Nigerian Bar Association, your colleague Olisa Abakoba, made the point recently that a big problem in all of this is, in his words, INEC at once being culpable and also being a defendant. He suggested that in a situation as we have, where INEC is an active defendant in court, the Commission will obviously want to show that it conducted the election in accordance with the law. He's saying that it would be better if INEC was not a defendant and was simply called to submit evidence about what transpired in the election, rather than having the burden of defending the election that it conducted. Do you agree with his submission?
Well, I'm happy that some of my colleagues are beginning to appreciate some of the points some of us have made earlier, much earlier. I had maintained long before now that the onus of showing that a good election has been conducted should shift to the INEC. And again, this was one of the recommendations of the Ways panels.
That
because
is true.
you said you have conducted a credible election. Prove it. Once there is a genuine petition raising serious questions, the onus should shift to INEC, because it's very difficult. And this is not a Nigerian phenomenon alone, where you expect the respondent who doesn't have the election materials to adduce sufficient evidence to show that the election, or to prove that the election was not conducted substantially in accordance with the law. It should be the other way around. But for now, yes, the point Elisa has just made, INEC would naturally want to go to the tribunal or the courts of appeal to say, we conducted credible elections. However, INEC has also made a point that there were challenges.
Yes, it did say
with
so.
respect to the deployment of technology and the conduct of electoral officers. And INEC had also threatened, or INEC had promised Nigeria, that the electoral officers who abused their office or the confidence of Nigeria will be brought to book. And I would have wanted, for instance, some of the petitioners to invoke the provisions of the Electoral Act, because the courts and the tribunals are empowered to recommend the prosecution of those who are proved to have manipulated the elections, to have inflated figures, to have, one way or the other, betrayed the confidence of the electorate. If such evidence is adduced, the tribunal or the court is empowered by the law to recommend the prosecution of anybody who is indicted.
Yeah, but I think the people...
And we have not been doing that.
Yeah, that's a good point. But you know, the people who are going to court are much more interested